Once again, welcome to Legal Matters, the program that's been designed to address the timely, relevant, critical, sometimes contentious issues that are facing businesses and consumers today. It's legal information, practical solutions, and straight talk about a wide variety of topics that will affect your home and work life. And today we're going to be addressing the topic of criminal law, something that we hope you never need to deal with, but if you should, we have you covered. What you need to know and hope you never need to know it. Violations and citations and misdemeanors every step of the way, from arrest to whatever. So let's first welcome from Odette Bazar, Grasso law firm in East Providence, Jackie Grasso to my left, and to her left, David Bazar. Okay, so what do we need to know? I guess there's a hierarchy of offenses. Let's talk about what they are and what are each of the stages about. Who's to begin? So
we want to start with felonies, which are the most serious crimes. It can be murder, stealing, robbing over a certain amount, larceny. Felonies are crimes in Rhode Island that are punishable by more than 1 year in prison or a fine of over $1,000 or something of that nature. Then misdemeanors would be less serious crimes, but crimes that are still punishable by jail for up to a year and a fine of up to, I think it's $1,000. It was $500 at one time. And those could be anything from disorderly conduct to larceny under was a certain amount was $500, maybe raised it to $1,000, and other types of things. Petty misdemeanors are more of a criminal sanction that are even on a lower level than that. Ordinance violations, which Jackie and I cover in municipal court, and traffic offenses, which are more civil in nature, unless they rise to like a reckless driving or something like that, which would be a misdemeanor in district court.
Are there differences, wide differences between what constitutes a felony or a misdemeanor in Rhode Island versus Massachusetts, or are they principally the same?
They're principally the same.
There's, what might constitute a felony in one state and a misdemeanor in another may have slight differences, but the definitions for the most part are the same.
In Massachusetts, you have shoplifting under a certain amount, it would be a misdemeanor. Over a certain amount, it would be a felony. It's similar in nature in Rhode Island. In Massachusetts, we don't have traffic courts or traffic tribunals, so any traffic-related offenses would be heard in the district court.
I understand that prisons are swollen, and in some states, I don't know about Rhode Island and Mass particularly, but in some states they're thinking about reclassifying who gets to be sentenced to prison relative to being convicted of a felony. Is that now a sliding scale in Rhode Island and Mass? Are they thinking about reclassifying? I know at times they change the definition. What's the status right now?
Not to my knowledge.
Yeah, Rhode Island, for the most part, the judges have the discretion of who's going to get sentenced to prison and serve time and who isn't. A lot of times those types of things are worked out at a pretrial conference between a defense attorney and the Attorney General's office. But the legislature hasn't come in and said, no, we're going to, except for the declassification of marijuana possession on small scale.
A good example.
That's changed.
Yeah, it's changed. But beyond that, they're not going and looking at, well, we have too many people in prison, so we're not going to send someone to prison for, statutory rape. They'll get home confinement. That's still within the discretion of the judge who sentences somebody who's convicted.
But in federal court, you have mandatory sentencing guidelines, so the judge's discretion is not as broad as it is in the state court.
Although there have been some case law trying to give judges more discretion, but Jackie's 100% right. Yeah. They have these guidelines that sort of define what the sentence is supposed to be, and there's very little deviation from that.
And I believe in California they have that 3 strikes you're out rule, so if you're picked up 3 times for drug offenses, then you could be incarcerated for life. And that was a controversial issue as well.
Apparently that's even discussed even in Rhode Island right now.
Right.
And depending on whether or not you have good legal counsel, you might have an indefinite amount of those. But without being really political about that right now, I know we wanted to discuss criminal law, but can you make the distinction for us between criminal and civil law, where the onus is on prosecutors and whatnot? Difference between the two, Jackie?
Well, let's talk in terms of tort. So tort is a legal wrong. So you could commit an assault and battery and that could be considered a tort. You could be sued civilly for that, for damages. You could also be sued criminally for that because the assault and the battery may have done damage or physical harm to the person. So it can be heard on two levels. On a traffic offense, the ones that David and I hear, we hear driving, not driving suspended. If you're driving under 15 miles an hour, we'll hear those cases in municipal court. Those are civil in nature. If someone fails to show up for court and ultimately the license is suspended and the person is caught driving with a suspended license, now it moves from a civil matter into a criminal matter.
So Jackie's 100% right. And on the distinction between the civil and the criminal, using Jackie's example, the person who is injured by the defendant, say, is the one who sues on a civil case and collects money damages. The state of Rhode Island, the Attorney General, prosecutes the criminal action, which could be the same conduct. That case is within the discretion of the Attorney General to prosecute, and the victim, although they may say they don't want to be involved in it, usually doesn't have the authority or make the call as to whether the case is going to go forward. It's a crime against society, and the Attorney General is responsible for protecting society.
And I understand that there's some distinction, some difference, too, between the criminal case with a prosecutor where there has to be a reasonable doubt, and I guess on the civil
standard of proof.
Yeah, the burden of proof is
beyond
different.
A reasonable doubt in a criminal case, so you have to have a unanimous verdict in a criminal trial, whereas in a civil trial, it's not the same standard of proof.
Right, it depends.
By a preponderance of the evidence. Yeah. It just depends on the type of case it is.
So the preponderance of the evidence in a civil case would be the plaintiff has to prove that it's more likely than not, if you will, that what he says is what happens rather than what the defendant says is what happened.
And you don't need a unanimous verdict.
Well, we do, but they usually have to weigh in. But what they do is you just have to tip the scale. Whereas in a criminal case, the burden of proof is beyond reasonable doubt, which has been debated as to what that means. It doesn't mean beyond all doubt, but you have to really convince a jury that this is what happened, and the burden of proof in that case is on the Attorney General's office to prove that case. The tickets that Jackie and I hear, between the two, it's called a preponderance of the evidence, that it's a clear and convincing evidence, that it's not the burden of proof is not beyond reasonable doubt, but it's not that preponderance of the evidence in the civil case.
Okay, in a criminal case, every juror has to agree that somebody's guilty. If one person doesn't agree that there's a guilty verdict, then you don't have a guilty verdict. And sometimes that's why juries end up deliberating for days and hours and hours. One person can hold out and it could lead to a mistrial.
Yeah, a hung jury, as they say. A
hung jury, yeah.
So let's go back to the initial stages. There's an arrest. What happens to the person who's arrested, and take us through the steps of arrest and bail?
Yep. So, you want to
when
start?
Somebody's arrested, the police have to obviously tell them what they're being arrested for. They have to Mirandize them, and if anybody's watched Law & Order or CSI, they know what that is. You have a right to remain silent. Anything you say or do will be used against you. They have to be Mirandized. They have to know what their rights are. They have to be given an opportunity to call an attorney or at least make one telephone call. In Rhode Island, if somebody is picked up after hours, meaning after the courts are closed, then the police department can call a bail commissioner who can come out and have a mini bail hearing and determine whether or not the person can be released, either on personal recognizance or posting a small amount of money. But bottom line is the person has a right to be arraigned in front of, has to have an arraignment within a certain amount of time. They go before the court, even if they are bailed in the evening by a bail commissioner, you still have to appear in court for an arraignment. And then the case takes its journey through the pretrial process, and at some point you could end up in trial.
Right. So in a misdemeanor case, if the person is either brought in by the police the next morning or if they've been released on their own recognizance, and bail is personal recognizance, your promise to keep the peace, be of good behavior, and to appear. And if you don't, that bail can be revoked. Cash bail, a surety bail, if you're entitled to bail, they want some more assurance that you're there. The judge may say you have to post either a real estate as surety or hire a bail bondsman or post usually 10% surety in cash. and then you're released. After the arraignment, you come back for, in district court, a pretrial conference, and if that doesn't resolve it, you could have a trial. If you lose a misdemeanor in district court, you have the right to appeal to the Superior Court for a brand new trial in front of a jury. There are no juries in district court.
Now, unlike Massachusetts, there are juries in district court for criminal cases.
Right. So
Civil.
when you're arraigned, the judge will ask you, do you waive your right to a jury trial in the first instance? And if it were me, I would always have my clients do that, because it's sort of a free shot or a free bite at the apple, if you will, to convince the judge, if you think that your client is entitled to a trial and is not guilty, that that's the case. And if you lose, you have the right then to appeal and have the jury trial after that.
So you've gone through the quick outline of the
Misdemeanor.
steps for misdemeanor.
Not felony yet.
But if someone is arrested, what does it actually take? Is it easy for a police officer to be entitled to arrest? I'm suspecting that such and such happened, or that you did such. What kind of proof do they need in order to be able to actually issue an arrest?
Well, they have to have probable cause. So they have to have a reason to arrest. They just can't knock on your door and say,
I think you were there at that time?
Yeah, they have to have probable cause. They have to be issued an arrest warrant unless it necessitates an immediate arrest. So if a police officer is standing on a street and sees somebody commit murder, shoot somebody, well, then that's an immediate arrest. You wouldn't need a warrant for that. Right. But, yeah, they have to have a probable cause
So
to do that.
That's exactly right. So the DUI case, the police officer sees you weaving in and out of traffic or whatever his reasonable suspicion is to pull you over to investigate further. Then he comes up to your car, you roll down the window, and you have bloodshot eyes, you have a smell of alcohol, strong odor of alcohol, and you're slurring your speech, and they ask you to get out of the car, and then you fail the field sobriety test, because that's what it seems all my clients end up doing. They now have reasonable cause, what do we use? Probable cause to arrest you right there on the spot, and that's what happens. Now, we've heard that this Aaron Hernandez situation, they're doing an investigation, they're developing evidence, and now they have enough evidence, I've heard, that they might want to issue an arrest warrant for him where they go out and pick him up. They may negotiate him turning himself in, or his turning himself in, but that remains to be seen as of right now. Probably by the time people are watching this, he will have been arrested for something.
And the arrest warrant has to be signed by a judge. And the arrest warrant in that case is obstruction of justice because he allegedly destroyed a videotape at his home, or video surveillance and cell phones.
Right. So now when someone's arrested, the police bring them in, whether it's someone arrested on an arrest warrant or somebody who has been picked up at a scene of a crime, brought in. They are, as Jackie said, given their Miranda rights. They're sometimes questioned. Now, the Miranda warnings are to protect you from giving a statement without knowing your rights. And if they do take a statement from you without having given you your Miranda warnings, there's grounds for a defense attorney to block that from coming into evidence.
As opposed to that was an unlawful arrest. You don't need to Mirandize someone to arrest someone.
Right.
You just have to Mirandize them once they've been arrested.
Correct.
Is that correct?
Yep.
And what proof does the arrested person have? How does he say, I wasn't Mirandized? Is there are two police officers often around,
Yep.
but then it's two of them against one of them. What grounds does that person ever have to stand on?
There's a written statement that
statement.
says you were given your Miranda warnings, and you initial usually each warning.
Good to know.
Then you sign it.
They do that too. The bail commissioners do that as well before they release you.
That's exactly right. And the purpose for the police department is to say, well, I did go over it with you, and that's your initial next to each one, and that's your signature. So the burden of you proving that they didn't do that is sort of high when they have your signature on the page.
Although failure to give a your Miranda rights doesn't in and of itself negate the criminal offense.
No. And all it does is, for instance, if you gave a statement after that, that might be grounds to not allow your statement into evidence. So that could be excluded. But it doesn't mean that they didn't have grounds to arrest you and go forward with the prosecution without the evidence that you may have given against yourself.
You give a very good example, David, but how would that person be able to say, well, I made my statement, then they gave me the Miranda, but that means that statement should not have been admissible in court. It's not recorded, so how would they actually be able to have that play out and have that take hold?
Well, there have been instances of similar situations, and you can sometimes prove it with times that are put on papers. There are videos of people coming in and out of the police station, so there might be other evidence that you can find to prove what you're saying happened.
And I would think in this day and age that police departments have a policy that they inform them of their rights, and as David said, they'd have to sign a written document acknowledging that they have been informed of their rights before they even get a statement. Now, somebody may just blurt something out, okay?
Right. Mm-hmm.
Even before the arrest, the person might just blurt something out that incriminated them. Well, that's a different story because that person wasn't arrested.
Right.
And can you use that against them?
That's exactly right. You don't have the protection of the Miranda
Correct.
warnings until you're arrested. And then the definition of what's arrestment. If you're being detained at a criminal scene but not in a police station, is that an arrest at that point? And if you say something there, are you protected? And I think the Supreme Court has pretty much said in the U.S. Supreme Court that, no, if you just blurt it out, you're not protected. It's only when there's that detainment, that arrest, that you're protected with those Miranda rights.
Okay, lawyers, does that then mean, whether it was Hernandez and others, better to not say anything to the police who are asking you questions until you are arrested, Mirandized, and then
Absolutely.
Right.
then you have to
Right.
answer the
And
question?
if he had called his attorney, and his attorney would have said to them that if you want to question me, I will be more than cooperative, but I want my attorney there, and I'm not going to speak until he's present.
Good.
So the next part of the process, which we're going down with when you're arrested, is the processing, fingerprinting. And now there's also a case, I believe, that says that the police can take your DNA in a swab when
Is
you're
that
arrested.
questionable right now? Is that constitutional
Well,
right now?
there was a case, and I believe it's been decided in the U.S. Supreme Court, that said it's sort of analogous to taking fingerprints in today's taking of, investigative techniques, and that you can require someone to give a DNA sample
Only if they're placed under arrest.
after they're arrested.
Yeah.
Right.
And so you don't have an option with that.
While you're being processed, just like with the fingerprints.
You are put in a jail. Are you able to get out by placing a phone call and having someone bring money, bring the bond, bring whatever?
Depends on the nature of the offense. If
Misdemeanor
well, if
versus
it's a felony, and if it's a repeat offender, if it's a domestic, we have something called DNRs in Massachusetts, which is it's not do not resuscitate, it's
Right.
do not release. If you get picked up on a domestic abuse, violation of a restraining order, you're going to spend the night there, and they're going to bring you into court the following
And
day.
a lot of other types of situations, if you're really, really drunk and you're being charged with DUI, they're going to hold you overnight, and they're not going to release you in some instances. And if you're a flight risk, they're not going to release you. So,
Is there a guideline for how much you should be assessed for bail based on what you did? Is there a general, for this crime or this suspected crime equals this many
within
dollars?
the discretion of the judge.
it is within the discretion of the judge, but there are certain principles that go into it. What's your connection to the community? What is your flight risk? What is the charge against you? Because the more serious the charge, I would say more likely that you might not want to show up for that. So there are all of those factors that go into the judge's setting of bail. There are some cases, some crimes, where the judge doesn't even have to set bail.
And he would do that because he just thinks it would be preventative, that you'd be doing some harm to someone? Or
Seriousness of the crime and that type of thing.
So every defendant does have an absolute right to a bail hearing, and that's what David's talking about. They
Right.
actually have a full-fledged hearing on the issue of bail.
Right.
Discuss the idea of the bail and the money that's supposed to be put forth. I understand there's cash, there's also a bond. I understand that if you go to the court, you are able to have that money back. If you end up having a bond, how does that change it? You have a percentage that you have to pay. You might not get that 10% back or whatever.
Right.
How does the bond work?
If you
Explain.
hire a bail bondsman, he's entitled to be paid by you for his services. So the money you pay is a fee to the bondsman.
That's what the 10% represents?
Well, 10% surety bond, if you put up the 10%, if you put up
Okay.
the 10% of what the bail is, then it's your money. And if you're not convicted and you've shown up to every court case hearing, you'll get the money back. If you're convicted or you plead and there's money due, they may set off some of the court costs against what you've posted and then return the balance to you.
Is it generally true that you would pay less if you were to pay the bail yourself versus having a bond with that administrative fee plus the 10%? Would it cost you less generally?
Sometimes you do need a bail bondsman because people don't have the money, so they have to put up collateral. Oftentimes what they'll do is they'll look to a relative to put up a house for collateral.
Right.
And if they take off, then
not
going to have a very happy relative.
Right.
And about felonies, generally you don't have a likely chance that you're going to be getting out of jail free the next day?
There are felonies that are all subject to bail, that are bailable offenses.
In theory?
No, usually.
Interesting.
Unless if you violated probation, you might not get out. If you're already on bail and you violate bail, you might not get out. But they can only hold you for 10 days for a bail violation, and then they have to bring you back in for a hearing. So you always have a right to a hearing at some point in time to be released. Unless now you've been convicted and sentenced, that's a different story. But felonies, we didn't get to the process with that, so we can quickly do that a little bit.
It's a good time to do it.
So you get your first hearing, which is an arraignment. And then from the arraignment, it's usually set down for what we call a PAC conference, which is a pre-arraignment conference. Now, cases can get back to the PAC conference in two ways, really. One way is the Attorney General can look at the information packet that's been presented by the police department or whoever the charging officers are and decide whether there's enough evidence in there to file an information, which is their version of a charge against you. And at that point, you go to the pre-arraignment conference, see if you can resolve it. If not, then you're arraigned because you're first arraigned in district court. Then you're
everyone.
Yeah, for almost everything.
Okay.
There's no plea taken on a felony because in district court you can't plea. They don't have jurisdiction over a felony. So that's when it goes to that pre-arraignment conference. If it's not resolved at that level, you have an arraignment set in Superior Court. You're then sent to a pretrial, and then if not resolved there, to a trial. The other way you can be charged in Superior Court with a felony is through the grand jury.
And a grand jury could indict a ham sandwich.
Right, so they say.
What point do we need a lawyer? At the time of the arrest, the time of the arraignment, felony or misdemeanor?
As soon as they offer you that one phone call.
Yes.
And if you're indigent, you have a right to a free attorney. And what they'll do is they'll let you go down to probation office, fill out some forms to determine whether or not, the public defender's office, to determine whether or not you do qualify for a free attorney. And so you have to fill out a financial form.
Before they will even determine that you're entitled to a free?
Correct.
Okay.
Yeah, because you're entitled to an attorney, but depending on the charge and your income and ability to pay for it yourself, you may not qualify for the public defender.
Okay. At what point does an attorney get actively involved in the case? At the arraignment, we don't think that person should be arrested. We don't think that there should be a case. What point are you actively involved?
We talked about a case already with this person may be facing an imminent arrest warrant. If I were him, I would have contacted my attorney already during the investigation, before he's even arrested. In this case, you know it's coming. You know there's information being gathered that may or may not put you in a bad light. You want to make sure you protect yourself as best you can. I would have already called the attorney.
Even if they call you down for a statement, you haven't been arrested, you haven't been charged.
Right.
Even as a witness, you can have your right to counsel.
And at that point, if he hasn't been arrested but is called down and he agrees to go, you
want to go with an attorney.
And at that point, would you be advising him of what not to say? Would you be coaching him with questions that he's likely to be, not coaching, but actually pose some of the question that he's likely to be asked?
Depending on the situation, he might not be answering any questions.
And you would advise at times?
Depending on what the situation is.
Okay.
And everyone is different. Every case has its own issues and the right way to proceed. There are some cases where you want to be in there with the client while they're giving their statement, and if they ask a question that you'd think is beyond the bounds, you might say you're not answering that. And they may try to push you, and you may say, then the questions are over. But that is all dependent on what the facts of the case are. So every attorney has to look at that and determine where it is in his client's best interest to proceed with cooperating and talking to the police. What you can't do is give false statements to the police, and you can't mislead them, and you can't tamper with evidence, and you can't destroy evidence, because that becomes obstruction.
Taking a page from the television shows, the series, at what point should someone consider it's not a good idea to have a lawyer because, as I guess it's Law and Order, will offer you this unless you, quote unquote, lawyer up? How does that actually possibly benefit someone to not have a lawyer?
It doesn't.
It doesn't benefit anybody. That's just the police trying to...
Right. The police,
and could that actually happen? Would that likely take place in real life? Never mind on the
police
set.
have been given a lot of leeway in
Yeah.
what they can tell people and what they can say that may or may not be very truthful. But one of the things you're always entitled to do is to have an attorney. And if they're going to offer you a better deal, then you really want an attorney at that point, because you want someone to look at the paperwork and make sure that what you're getting is what you're getting. If you're getting immunity, what kind of immunity are you getting? Because there are different types of immunity. There's use immunity, there's pure immunity where you can't be charged with anything based on what you say. There's immunity where they can get other evidence and bring it in and charge you. And if it's not done right, they can even use what you say. So whatever you agree to, the attorney really needs to look at that document and make sure it purports that it gives you what they purport it to give you.
Good to know. Pre-trial and trial. Is a pre-trial really a trial before it's a trial?
No.
Differences?
We're going over evidentiary issues,
Conferencing on
motions.
what you might need to try to resolve the case, and negotiations to try to resolve a case.
Oftentimes, though, cases, more so with misdemeanors, they will resolve at the pretrial level.
Meaning it won't need to go to trial.
Yes, and by that time, your attorney will already have received from the police department a copy of the police report and any other information.
All of the discovery, we would call it. We request discovery from the police to say, what is the information, what evidence do you have, who are the witnesses, and then you go through all of that and you determine whether or not there's a case and what might be the best result for your client, and then you go to the prosecutor and try to work it out at the pretrial.
Okay, but there is negotiation at several different levels, is that correct?
Always negotiation.
Yep. Even at trial.
Even if you impanel a jury.
You can still, while the jury's out, you can be negotiating.
And if there's a guilty verdict, then there's still another reason for, or another last hope in the appeal process?
Yeah, but that's based on whether the judge who was overseeing the case made a mistake in allowing certain evidence in or gave a jury instruction that wasn't correct. You don't want to be at that stage if you're the defendant. Assuming
that not every trial is perfect anyway, as long as it wasn't going to affect an outcome. Also about sentencing, they could possibly do that, correct?
Right, they can appeal to determine whether the sentence was appropriate.
Okay, good to know. I think we probably could go through this a little bit more detail, but I think at this point we're about ready to wrap up, so we should say that we hope that you don't ever have issues with felonies and misdemeanors or arrests, but if you do, we hope that you are better prepared to deal with it. Thank you, and stay tuned to legal matters.